Hello and welcome to the third session of the risk management and insurance component module of the PMT course. I'm just going to pull my presentation up as we continue dealing with the internal controls that you can implement in your firm. Know that a lot of what I'll cover in this component you may think is common sense, but that's what risk management is in many instances, really a failure of people to implement the very basics in the firm. So in today's session, we will look at file audits and file management, supervision of staff, and implementation of a peer review system, and then also look at segregation of duties. When we're talking about file audits in this context, we are not talking about the audit on your financial, the financial audits, or on about the regulatory audit that is conducted once a year. This is a review on how the matters are actually handled in your practice, and this is the review is conducted for your own benefit, and so that you can see the health of your practice, proactively identify any risks and any areas that need improvement. It is good practice to conduct the file audit at least once a year. That is, that each active file will be reviewed at least once a year. You can decide how you want to do it, how you do it periodically, whether it's monthly, quarterly, or if you of the view that 6 months, a 6-month period is adequate, you can do so. And you will also do this by drawing a sample of files. You do not need to review all the files in one sitting. So you can decide how many files you'll take out of your entire practice to look at it one time. It's also a good system to ensure that you have a representative sample. So if you conduct different areas of practice, litigation, commercial work, conveyancing, maybe debt collecting, ensure that all those areas are represented in your sample. If there are different people that you have employed in your practice working on files, ensure that files from all the respective areas are included. There are a number of benefits of doing this. It will help you identify whether all the matters in the practice are being attended to timelessly, first of all, and secondly, whether the standard of the output is at the required level. You'll also be able to proactively identify any potential risks before they materialize. So you'll see red flags and you'll be able to implement corrective action so that these do not result in claims against your firm. It will also allow you to gain some assurance from all the functions in the practice that they meet the regulatory requirements. You can also check the finances in order to ensure that financial transactions have been carried out accurately and that there's a proper audit trail for those financial functions. This will assist you in preparation for the annual audit that will happen. So you wouldn't be confronted with issues for the first time when the audit occurs. You'll also be able to identify areas in your operations where you need to improve, and also areas where your staff need training. You'll also be able to see where the people are performing very well, and then that will assist in getting those people that are performing very well to train others in the firm that you see need some sort of assistance to bring them up to scratch. Some of the other benefits of conducting the file audit process regularly is to assess compliance with your own internal operating standards, the early alert system for the detection of errors, and even unethical or unprofessional behavior. There may be things that you will uncover during the audit that may lead you to have to embark on disciplinary action against the affected parties, or even to report those proactively to the Legal Practice Council. Because certain types of behavior, if you try and hide them, you will only be digging a hole for yourself, because they'll come out in future. You can use this when you're doing the performance appraisals for your staff. You'll also be to assess your own effectiveness as a supervisor and as the person responsible for the practice. You'll identify certain people or certain functions that need more of your attention and assistance, and where people need training, you can then provide the necessary training. To provide you with valuable information in respect of the effectiveness of the risk mitigation measures you have in place, and to see where there are things that are potentially slipping through the cracks or have already slipped through the cracks. This information will be useful when you complete the annual risk self-assessment questionnaire. The completion of the annual risk management self-assessment questionnaire is compulsory when you apply for your fertility fund certificate, and in the event that your firm has a claim and you notify the LPWI of the claim, you will submit the same self-assessment questionnaire. And this will help you detecting all the matters that your firm is being dealt with, because as you'll note from some of the cases that I will refer to later in this session, there are instances where practitioners inform us that they were not even aware that certain matters were being dealt with in their practices, and the first time they became aware of the matter was when the summons was served on them, or where a complaint was laid with the Legal Practice Council. So how do you go about conducting the file audit? You'll have to start off by drafting a checklist, an audit checklist of what you will be looking for in each file. Do not despair. There is a precedent available on the LPWI website if you do not have such a checklist. Go through the process of the file audit and ensure that that file audit checklist is retained, whether it's in the file or somewhere else safely for future reference. And it's best to get a senior member of the firm to conduct the audit. If you have junior people or administrative staff doing it on their own, essentially you are asking them to do a self-review, and they may paper over cracks or hide certain information from you, which is crucial for you from a risk management perspective. It's also prudent to audit files before you close them. This helps you ensure that all the loose ends have been tied up, that there's been a proper accounting and reporting to clients and other third parties. And that will help if a little while down the road, any of those parties decide to institute action against you. You'll have the benefit of having conducted an audit when you close the mandate, and will thus have the assurance that you've done all that you needed to do. The type of issues that you could look at, or the type of areas you could look at in conducting your file audit, are whether the Financial Intelligence Center Act and all other legislation have been complied with, whether there's a letter of engagement in the file that is dated and signed by both the client and the firm, that the mandate has been carried out without unnecessary delays and there's been no procrastination, that you've had regular communication with the client, and both the file notes in that regard as well as the correspondence is on file. One of the triggers for the breakdown in the relationship between clients and firms, which ultimately result in professional indemnity claims, is that breakdown of communication with the client. You can also check whether your file is properly maintained in accordance with your internal operating standards, that there are file notes in respect of all attendances, and that reading the file, you can tell this that the story of the life cycle of the instruction from the beginning until the point where the file is at. Also, you can check whether your billing policies have been complied with. Have you rendered accounts to clients regularly? Are there any matters where work has been done, but there's been no accounting to clients, and therefore you haven't received fees to assist with your management of cash flow? Check that all the accounting and finance matters are in order, that deposits into the trust account have been done properly and they accord with your own internal rules as well as those of the regulator. Also, insofar as the output is concerned, or the quality of that output, that the law has been applied correctly to the facts, that the service that has been provided that is being provided to the client is of the appropriate quality. If there are any prescription issues, you can pick those up timelessly, and also see whether there are any whether there's appropriate oversight in the handling of matters. You can, depending on what area of practice you are in, you can adapt the checklist to suit those types of services that you render. And just a few pointers on file notes and file order. When we receive notification of claims, we ask for the full file contents. The state of some files is really shocking, and when you go through them, it's not surprising then that the errors have been made. We see instances where there are documents missing from the file. There are documents that have been misfiled. Something as simple as filing the correspondence chronologically hasn't been done. That results in someone picking up the file not knowing what is going on, sometimes there's action that needed to be taken in the matter, some sort of activity, and the person picking up the file could not make that out from the documents before them, because the file is in just such a terrible state. The state of your file also talks to the quality of output that you are giving to your clients. It's important to take detailed contemporaneous file notes. Take file notes as events are happening, or as you're having with a discussion with the whichever party it is you're talking to, whether it's a client or a third party, and follow that up with correspondence confirming the discussion. In some of I'll refer to a case later where the defense of that the legal practitioner concerned was successful, and one of the reasons why his defense was successful is that he kept detailed file notes. On the other hand, to give you an extreme example, we dealt with the matter a few years ago where an attorney was facing litigation from a long-standing client. This client had a relationship that spanned over many years. While we were investigating the matter and asking the attorney for documents and for his files, he was giving them to us, and we looking at it and at all the information provided and having discussions with him, seemed like everything was in order until the day before trial, when he contacted the legal advisor who was dealing with it and told her that there were problems. He had fabricated a lot of that. The file notes that were in the file had been manufactured after the fact in order to support a version he was trying to convince his client was true. That is fraud. Needless to say, that practitioner was then left to face the music on his own. Where is further action required? Please note it and give a due date for the action. We've seen a lot of times that consultations or meetings are held, different matters are discussed, different action items are identified, but no date is put for them. Please, in the meeting, ask for dates, and even if you are expected to carry out certain things, and you please put a date by which you are to carry those out, so things are not left open-ended. The file notes will also help you in the event of a complaint to the Legal Practice Council. If the client says that you have not been attending to the matter properly, and or that the matters you haven't been giving the matter the appropriate attention, file notes and the general state of your file will assist you in your defense in that regard. If there's a dispute about fees and the client says that you are charging them for attendances that didn't happen, the file note and the correspondence that followed those file notes will assist you. If you are taxing a bill of costs, there's a dispute about the attendances, the same situation. File notes will assist you. If in the event that your firm is facing a claim, as I've said, these could come to your defense. When the file is transferred to someone else in the office, a well-organized file makes it easier for the new person taking over to know exactly what was happening. If there are no file notes about certain discussions, there are going to be gaps in information, and that is a risk. Also, insofar as transferring matters between people in practices, make it a practice that when someone leaves your firm, they need to do a memorandum or a note on each matter that they are dealing with, on what has happened, what the current status of the matter is, what next steps need to be taken, and any other information that the new person picking up the file needs to know, because that's also a very big risk, the transfer of matters between people in practices. And this is whether someone is moving from one department in the firm to another, or whether someone is leaving the firm altogether. I've given you a list of the resources that you can consider there. The PJ Nienaber versus Pierre Kitching attorneys matter is the one I referred to. That it's the attorney in that matter kept detailed file notes which assisted us in the defense of that claim. The article in the October Risk Alert, October 2021 Risk Alert Bulletin is really about two cases. In the first matter, an associate employed at a firm accepted an instruction from plaintiffs who were suing the Minister of Police. The principal in the firm, the sole practitioner, wasn't aware of that because the associate was given some sort of leeway and independence to operate on his own. He left the practice, and the claim prescribed. The plaintiff sued the attorney. The attorney said he had no knowledge of this, of the matter. He disputed ever having received a mandate from them, and his defense was run on that basis. It later emerged while we were preparing for trial that in the practice there was a document, a book rather, which was like a register where all clients coming in for new matters would enter their details. There was the date, the type of matter, and just a brief description of why they were at the firm. That came out just before the matter went to trial, and when we traced and found the associate who is now left legal practice, and speaking to him, he confirmed that he was running the matter. After considering the position, that matter had to be settled, and with the full limit of indemnity had to be paid to the plaintiffs, because we could not dispute either that there was a mandate or that the claim had prescribed in the hands of the firm. When that associate left the firm, didn't give a proper account of the matters he was dealing with. The second matter in that October Risk Alert Bulletin is also a prescription of a claim against the Minister of Police. In that case, the attorney said that he lost some of his documents. They were blown in the wind while he was moving offices, and he couldn't retrieve them. He disputed his mandate, yet in some instances, in others, he accepted that there was a mandate. The attorney testified as after the plaintiff. The court found that there was indeed a mandate, and the attorney was liable. So just the last bullet is just a link to the file audit precedent. When you go on to a peer review system and supervision, the idea of a peer review system is one which we've taken from the audit environment. For many years, auditors had a system, well, in most of their firms, that no audit report would go out to a client unless somebody else in a partner peer reviews it. And this is even if the audit itself was conducted by one partner. So partner A runs the audit, completes it with the team, and then prepares the audit report, goes to partner B to review before it's sent to the client. It's the same principle that we are advocating for law firms. This is will help, because having a second pair of eyes look at your work before it goes out, that can give you the assurance, at least, that if you've missed something, somebody else can pick it up. It also assists in when you are chasing tight deadlines and trying to get documents out. You may miss something. Somebody else will pick up. On the other hand, if you have been working in a matter for a long time, drafting documents, and you keep updating and going through version after version, there comes a time that you are so invested in the document that you may be blindsided by something that you did not consider, which your colleague in doing the peer review system, in conducting the peer review, may pick up. So peer review is a good system to pick up, to mitigate risks and to prevent anything falling through the proverbial cracks. The lack of supervision of junior staff has been highlighted in many of the claims that we deal with, as well as in the judgments that are handed down in these matters. Yes, it's good to empower people, to give them some level of independence, but as I keep saying, the buck stops with you. You need to be to check their work from time to time. Give them space to be and the safety to be able to come to you if they're uncomfortable about something, or if they are unclear. Don't let them go out on their own and make mistakes. You will be left with those. In the two cases I mentioned with the claims against the police, which prescribe, had there been adequate supervision of the people dealing with those matters, they would probably not have resulted in the claims. If you are in a small practice or even a sole practitioner, you may ask then who will you use for your peer review system? Secretaries, candidate attorneys, and paralegals are very, very useful people. They are resourceful and in many instances very diligent. They have an important part to play, and empowering them to just look at your documents for you. They will learn from that, but they will also pick up any potential areas. A peer review system will also help with the risk I referred to earlier, with when somebody leaves the practice, because if you take peer review and a peer review system and a file audit system, it means you get a good insight into what is happening in the practice. When somebody leaves, you won't be left with a gap that you were not aware of. Files with this no activity for extended periods are also potential risks. Some people live by the adage that of letting sleeping dogs lie. I will say that those may not be sleeping dogs, but those may be mambas waiting to strike. If there's no activity in a file, there are a number of steps that you can consider. Should you rather close the file, have the discussion with client, close the file if you see that the client also doesn't have an appetite for the matter, and then do so. But importantly, send a letter to the client confirming your discussion. If there are any further steps that need to be taken in the matter, please take them. Sorry, please advise the client in the letter that those steps need to be taken. Maybe a prescription date that's coming up. It's maybe a court date that's on the horizon, or some other action that needs to be taken in the matter. Advise the client. Another option that you can consider is to refer the client to another attorney who may have more appetite for the matter than you do. A third option, which I read about recently from an attorney in the USA who specializes in professional indemnity claims against attorneys, is that he says that practices should consider a rotation system, which means that if, for example, a file has been on your desk for a month and you still haven't opened it, after a month it should move to someone else in the practice. The person that receives it cannot then also sit with it for a month. They need to read it, do something in the matter, even if it means that they do a review and draft an opinion for internal use for what they think the matter should, what they think should happen to the matter. And in that way, otherwise dormant files are revived. Invest in training your staff, because you will reap the benefits thereof, and you'll also avoid claims. And empower your staff to manage up, which means that your staff should be empowered to be able to guide you as the manager, as the head of the firm, on where they think that there are improvements that need to be made on possible risk areas and the like. A lot of the publications that we put out go out to legal practitioners who don't read them. We get a lot of useful feedback on the risk management areas we raise from staff members in firms. They tell us this is not that they are reporting their employers, but they'll say that, oh, if we came across a similar instance, or they know of another firm that had something similar, and we also learn a lot from them. So please empower your staff, because they are closer to the front line than you are in some instances, and can give you a lot of lessons. Segregation of duties is important. You cannot have one person in the financial area of your practice who can requisition a payment, authorize it, and then make the actual payment. You need to have a segregation, because that will give you some sort of oversight. And when you are called upon to authorize payments, please be careful of payments that come to you and they are extremely urgent, and you need to make them quickly, and you do not have time to actually check the background, or to ask questions, and there are insufficient documents. If you are uncomfortable, rather stall the payment for a while until you have all the information, until you are sure that you are making payment from the correct file to the correct person in the correct amount, that the account numbers are correct, then the reason for the payment is a valid one. We were notified of a claim that was rejected because it fell out of the outside of the LPWF policy, but the facts were interesting. A law firm which had, if memory serves me correctly, there were 3 partners. One partner responsible for the conveyancing department and the deceased estates department. That partner was very busy, spent a lot of time outside of the office, in the deeds office and at the master's office. The staff working in the estates department then concocted a scheme. Because in deceased estates, there are to be payments made to creditors like municipalities or clothing stores or furniture stores at times, they decided that they would start slipping their own accounts into into those batches for payments. And they also knew that the partner that was the head of their area was very diligent. So they would take the chance while he was away and go to one of the other 2 partners and ask them to authorize the payments and say that it was urgent. They knew that the other 2 partners were not diligent in checking payments, and with the result that instead of the municipal account of the deceased being paid, the municipal and other accounts of staff members were getting paid. And then the staff members expanded their criminal enterprise. They started slipping the accounts of family members into the batches, and soon that expanded even further, and they started getting people in the broader communities accounts, and they were having them settled for a fee. So be careful. Don't just flip through the documents and make a scribble and to try and give the person that is standing in front of you the impression that you've looked at it. Rather ask them to leave the documents, and don't do this in a rush when you're about to rush off to deal with something else, that you authorize the payments quickly before you leave. That is dangerous. Also ensure that the staff in the financial area take leave regularly, just so that they are away from the office. Yes, the majority of them are honest people, but it's that small minority of dishonest people that you need to be aware of, and you'll never know this until problems arise. So people who are at the office absolutely every day, get there first. They're the first at the office every morning, the last to leave every evening. Never take sick leave, never have to family emergencies that they need to attend to where they can't be at work. The type of people who are so diligent, you can phone them at any time of the day or night, and they can give you an explanation for every payment that has been made, or every other financial transaction in the firm. And if you cannot find the supporting documents, or if you have certain queries about transactions, they have a story to give you, which sounds like a plausible explanation. Those are also red flags. Please be aware of them. Some useful resources that you can have regard to is first are listed in on the slide. Please look at them. These are all articles that are available in Database. You can access the Database on the website www.database.org.za if you do not have the hard copies. And thank you very much. That is the end of this session, at the end of session 3. We'll be back together in session 4.